His evidence did not name any alleged official. That leg of the allegation was not proof either. The allegation of vote pardon in favor of second respondent was denied by both respondents. Having been so denied, one expected the petitioner to adduce credible evidence to prove it. However, the only evidence adduced on this issue was the tendering of Exhibit F, the spreadsheet containing samples from 26 constituencies showing the alleged vote pardon. To be specific, the allegation, as stated at paragraph 36 of Mr. Nketiah's witness statement, was that when the votes of second respondent obtained in all polling stations as shown on their respective pink sheets in the 26 constituencies are aggregated, the resultant figure differs from the figure that was declared by first respondent for second respondent as captured on the summary sheets of the respective constituencies. Having alleged as above, one expected that the pink sheets of the 26 stations in the 20 pink sheets of the polling stations in the 26 constituencies would have been exhibited to prove the vote pardon as alleged. This was not done, apart from the spreadsheet, which was self-serving document. PW1, Mr. Nketiah admitted that what he had tendered were only samples, but no effort was made to submit the rest, if indeed they existed. Besides the allegation of vote pardon, the petitioner also alleged that there was wrong aggregation of votes, totaling 960 votes in favor of second respondent. This was contained in Exhibit E, tendered by PW1, Mr. Nketiah. We found the allegation of vote pardon very serious, since its occurrence undermines the integrity of an election. Its impact being that votes are unlawfully added to the votes of a candidate to increase the total votes of that candidate. We have observed already that this allegation was not proved as expected of the petitioner. However, assuming the votes pardon of 4,693 took place at all in favor of second respondents as alleged by PW1 in Exhibit F, this court would then have to ascertain its impact on the final results declared by the first respondent. Indeed, evidence on record clearly showed that the impact of the alleged vote pardon, even if proved, would have been very insignificant and would not have materially affected the outcome of the elections. It would therefore not have been a proper ground for the annulment of the 2020 presidential elections. This is so because if one deducts the alleged votes pardoned from the total valid votes obtained by the second respondent, he would still have crossed the more than 50% threshold required under Article 63 Clause 3 of the 1992 Constitution. This fact was established through the cross-examination of PW1, Mr. Nketiah, on 1st February 2021 by counsel for the second respondent as follows. Question. The original figure is 6,730,143. Subtract from the 4,693. What do you get? Answer. You get 6,725,720. Question. What is that figure as a percentage of 13,121,111? Answer. 51.295%. So you see that even if you were to deduct your alleged pardon votes from the votes of the second respondent, he still crosses the 50% plus threshold. Answer. I disagree because samples cannot be subtracted from another population figure. We observed that PW1 from the above extract was merely being evasive, since it is obvious that if you take away the alleged pardoned votes of 4,693 from the total valid votes of the second respondent as at 2nd December 2020, as shown above, the second respondent will still have obtained more than 50% of the total valid votes cast, satisfying the threshold of Article 63 Clause 3 of the 1992 Constitution. On this issue, we are settled in our minds that the allegation of vote pardon, though serious in an election such as the presidential election, was not proved by credible evidence. Furthermore, even if the vote pardon took place same was not material or substantial to change the final results, so declared by the chairperson of the first respondent. In holding that the impact of the votes pardon, if even proof, could not have affected the declaration, we are emboldened by the decision of Lord Denny in the case of Morgan vs. Simpson, 1975, 1 Queen's Bench 151, which was cited by counsel for the petitioner in his closing address. We observe, however, that counsel for petitioner only referred us to only one of the 3 propositions articulated by Lord Denny. In that case, Lord Denny summarized the duty of courts in making declarations upon hearing election petitions. He stated 3 propositions as follows. 1. If the election was conducted so badly that it was not substantially in accordance with the law as to elections, the election is vitiated, irrespective of whether the result was affected or not. 2. If the election was so conducted that it was substantially in accordance with the law as to elections, it is not vitiated by a breach of the rules or a mistake at the polls, provided that it did not affect the result of the election. 3. But even though the election was conducted substantially in accordance with the law as to elections, nevertheless, if there was a breach of the rules or a mistake at the polls and it did affect the results, then the election is vitiated. When Lord Denny's propositions are read as a whole, the combined effect of the propositions is that an election will be voided upon the occurrence of infractions that actually affect the votes of the citizens cast at the polling stations, and not the incidents of administrative errors and or mistakes committed by officers charged with the conduct of such elections. We find this same sentiment expressed by our own eminent jurist Adinya GSC in the first presidential election petition case, Akufo-Addo and others versus Mahama and others. Number 4, 2013 Supreme Court of Ghana Law Report, special edition, page 73 at page 237 to 237 to 238. Her ladyship had this to say, quote, courts usually apply the election code to protect, not to defeat, the right to vote. Public policy favors salvaging the election and giving effect to the voters' intent, if possible. The right to vote is at the core of our democratic dispensation, a principle I've affirmed in